Can I just say something about Andrea?
Today was DVRO renewal decision day, and Ioan Gruffudd got his win. Now, it's a win. Obviously, he got the DVRO against Alice is extended for another 5 years. It's just like, did anybody really think this wasn't going to happen? Alice, did you think this wasn't going to happen? Because this was always going to happen. One of the things I did wonder very much is if the DVRO was kind of the main hangup as far as why this had to go to trial in the first place. I can't imagine that Ioan would have let it go, particularly with her behavior towards Bianca. I think it might have been one thing if she had just focused her abuse at him, but once she comes at his wife and also, puts his new baby in a position where the baby is getting threats and abuse and stuff, you're going to trigger that protective instinct for the family, and I don't think there's going to be any way that he would back off at that point. So Alice, it seems like to me, should have known this was coming. Before we get started into the details, because there was a fairly lengthy ruling. Of course, we had to finish up the closing arguments, but those really didn't take very long. We had a very lengthy ruling with a lot of interesting observations. Some of them, had me applauding. Some of them had me like internally screaming. So there's definitely going to be a lot to talk about. But one of the things I wanted to address before we get into the details of this order and how it went is what happens now in terms of the fee award. The fee award. Yeah, see, this is just part of the victory. This is part of the reason why, if this was really what drove Alice to trial, trying to fight this order, this was really ill-advised. Because this is also going to have downstream consequences for the finances, not just in terms of now there's a fresh finding of abuse that comes into play, and in terms of the factors that the court is required to consider in ordering support, but fees, attorney fees for the cost of this renewal process. Alice has to pay them under California law. This is what I wanted to share. California Family Code 6344. It's very hard for me to read on this tiny little phone, but the important part in it, it's the prevailing party. If the petitioner is the prevailing party, then the fees shall be awarded. This means this is mandatory. This is not a discretionary. The court can decide if he thinks it's fair to award the fees or not. This is, they will be awarded. And the only limitation on this in the statute is that the judge has to make a determination as to whether she has the ability, present or likely future ability, to be able to pay them. And I don't think this is going to really work very well in Alice's favor. We know she's going to plead destitution, I have nothing, etc., etc. But we're just about to go into several days. Well, at least 2. We got 2 more days to go into on financial issues. And, one of the big financial issues is going to involve financial abuse. And that's one of the claims here, one of the justifications that's being argued as a reason to deny spousal maintenance. And so to look at that, they're going to need to look at the financial claims and the financial patterns. And Alice's own financial declarations, her own income and expense declarations and so forth show a tendency to spend far beyond her means. Her problem isn't that she doesn't have the money. Her problem is that she can't seem to hang on to it. She's spending it on God knows what. And so that's not the kind of thing that is particularly helpful in weighing a ability to pay type of analysis. So we do this as well up in Washington when it comes to criminal fees and penalties and things like that. Washington is fairly progressive legally in that they did a whole bunch of reform that no longer allows these types of fees to be imposed if the defendant lacks the ability to pay them. And so when they say lacks the ability to pay them, this is defined in our law pretty specifically. It means things like you're at, your income is at, we set it at 125% of the federal poverty level, which works out to being like roughly $28,000, I think. Receiving any type of public assistance, these types of things will just per se mean that you lack the ability to pay. And this is clearly nowhere near in the ballpark of where Alice is. Alice has a lot of income. And so, yeah, I think this was a pretty big own goal. If this was the fight that she was kind of banking on winning, if this was the important thing to her and the reason why we're at trial in the first place, I don't think that was very prudent, because we were always going to end up here. I don't see how there's, like, unless you're completely delusional, the standard is so freaking low. It's just, it's extremely, it's not high. But even with it being relatively low, it was not difficult at all for Ioan to meet this burden with the evidence that was presented. And the judge went through it extensively, and so we'll talk about that. But then to have potentially incurred as well, the expense of the last 6 days of trial, at the very least, the first 4 days of trial that were, exclusively about the DVRO. But that's going to be a big old bill, plus the fees for the attorneys that prepared the renewal. It's going to be a big old bill. So it's just one more thing to add into that column of liabilities that Alice is potentially facing, because she would not be reasonable. She would not be realistic in settling this case, and she wanted to use it to punish him. So kind of seems like some consequences are starting to come her way. And I do wonder if she's starting to realize that. Also, before we get started, couldn't help but notice awfully silent from the Daily Mail. Quite shocked. They'd run some articles about how this is like the trial of the year. Big deal. They had the paparazzi sent there. We've had some few, pieces that had been released about, preliminaries and some of the evidence that's come out and so forth. Few days worth of articles, of coverage. They've had a reporter sitting in the courtroom every day. And then an actual decision gets made and it's radio silence. How peculiar. How peculiar. Almost like it's a little awkward now that whole $30,000 contract that they had with Alice, the abuser, is out in the public record. Strange. Very strange. So when I got to court today, I did remember to count the no photography signs on my way in. So I did not notice any no photography signs like when you first come in the front door, there's two entrances on two sides of the building. One is on the first floor because it's down a hill. It's on Hill Street. It's downhill, and the other is on Grand Street, and it's higher elevation. So you're on the fourth floor on that one. I go in on the fourth floor. It's kind of the main entrance because it's across the street from the Walt Disney Symphony. And that's the big parking area that the courthouse uses. And so like the jurors, if you're there for jury duty and you get a parking pass for your jury duty, that's where you get to park. So you just cross Grand Street and you go in that 4th Street entrance. It's where the photographers hang out. It's I think they're both big entrances, but for all intents and purposes, I feel like the 4th Street side is kind of the main one. So anyway, I did not notice specifically signs that say no photography around the security area, but in part that's because there are a lot of signs, a lot of different signs around that area. And so I'm just kind of like looking, and they're like signs, and I don't see the photography one, but also like even if there was one, I could see how it could be lost in the noise there, if you're not specifically looking for it. But as you walk down the hall towards the elevators, there is a no photography sign at the clerk's office. There are these large electronic boards that have the court's directory on it. So it tells you, here's the department, here's the judge in that department, here's the room that it's located in. So you know what floor to go to, that type of thing, because you would think it would be something simple like department 77 means room 70. No, it's a mess. There's sometimes like department 90 something is in room 600 and whatever. So it's on the 6th floor. So you kind of need the directory. At the bottom of the directory, there is a notification, no audio or video recording of court proceedings without order of the court. So 2, just kind of on the main floor as you're going to the elevator. Go into the elevator, go up to the floor that we're on. Once you come out, there are signs on like every single courtroom door as you're going down the hall. Some of them are big, like engraved plastic signs. Some of them are more like paper, flyer types of things. Like they're just all of these different formats. Our courtroom is all the way down at the end of the hall. And so I counted the 2 on the 1st floor and then 6 that you pass on the 7th floor before you get to the courtroom. Then when you go in the courtroom, there is a sign that is plastered on the front of the judge's bench. So like right as you walk in, you're looking at the courthouse, the courtroom, the bench is staring at you. The sign is right there. It's like staring you in the face as you walk in the door. So yeah, for this judge's courtroom, you have a total of 9 signs that you're confronted with by the time you are sitting in your seat, waiting for your hearing to be called. Had a lot of opportunity to become acquainted with that rule. Now, of course, in fairness, the previous courtroom that this happened in, Judge Freeman Stein's courtroom, I didn't even think about it until I was already gone. I'm like, I should have gone to his courtroom and checked it out too, but I didn't. It isn't quite so far down the hall. It's closer to the elevator, so you might not pass quite so many signs. You might only have like, I don't know, 6 or so that you go by before you get into his courtroom. It's still a freaking lot. Okay, they have the signs everywhere. They have the signs everywhere. Alice was wearing her pink and sour milk dress again, that skirt, same outfit really from the first week. I'm sure it was the Manky Tank underneath, like it was last week. Black jacket, short black jacket, little epaulets, on the shoulders. She never took her jacket off this time, so I don't know if it was the Manky Tank, but just from the cut of it, it looked like the same outfit that she put together with the pink and sour milk skirt last time. Before court got started, I did hear Joe and Janina once again talking about scheduling. And so I got some insight into why it seems that perhaps, Janina had made that comment about wanting Friday off, which, by the way, just jumping ahead, doesn't look like that's going to happen. We are going to have court in this case on Friday. So not going to be an issue. However, they were just talking about their respective trial schedules because Peter wasn't here today. Peter is handling a trial in another county. Janina is talking about how she has to start a trial on Monday, a big DV trial starting on Monday. Oh, really? Oh, did you learn about DV for that one? And Joe talked about just finishing a 15-day trial down in Orange County, and everybody was like, ooh and ah over that because Orange County is a fairly long drive from here, particularly with traffic. Oh God, if you have to drive the 5 from Los Angeles down to Orange County during rush hour, I would have, wake up in a cold sweat, nightmare dreams about something like that. It just sounds like the most horrifying thing that that I can think of from a sort of work quality standpoint. But so that was just kind of like some casual chatter, but it did give me some insight into why Janina wanted an extra day, because she's going to have to go straight from this trial to the next trial. So guess what she's spending her weekend doing? We had yet again another new court reporter, so had to state the appearances again. Everybody stood. This time we get Alice. She stood very stiffly, like this very awkward, stiff, upright hands, very stiff and straight kind of pose, and no smile today when she's announced to the court. So did she know what was coming? Did she anticipate? I don't know, but wasn't really in the mood, I guess, to try to charm the judge at this point. So we start with the judge getting us up to speed. We've been in the closings for the DVR renewal stage of the trial. We have heard from Ioan's counsel. We are now hearing from the respondent's counsel, so please proceed. So Janina took the floor and starts where she ended with the third Ritchie factor, which is the burden that the domestic violence restraining order imposes on the restrained party. She again reiterates that Ioan had contended that there was a physical assault, but he didn't provide any details or anything like that. So it's kind of appropriate to pretend it didn't happen, just disregard it, and consider this third Ritchie factor, which only applies in cases where there's no allegation of physical abuse. So the burden that she relies on is Alice's testimony that she's lost jobs and income amounting to about $50,000 a year. She anticipates Joe's argument that, well, she didn't put it in her income and expense declaration, but the question on that, she goes through the questions on it, and all it asks is whether there's been anything that's changed regarding her earnings, anything recently that's changed. And this wasn't a change because she didn't even start working the conventions until after the domestic violence restraining order was imposed. So it wasn't really pertinent to answering that question. Now, I found this to be a rather peculiar trying to have it both ways, because you're saying you had an impact of losing work, but you're also saying you were able to start a whole new career after this DVRO was entered. So it seems to me to be a kind of awkward position to be arguing a burden in. I think her implication or her point was she would have had more work, but for the DVRO. But just came across as I don't know. It's quite self-serving and just a little bit kind of inherently contradictory without a little bit more specificity. about what the course of events has been. So don't hold it against Alice that she didn't put it on the income and expense declaration, because that question isn't really going to that. And then she did present the Instagram post that showed that unknown third parties had contacted her employers. They were calling her an abuser. You shouldn't hire her, etc. And then don't hold it against her that she didn't produce the stuff in the deposition, because the deposition notice and the specific demand was for documents regarding efforts to obtain employment. And that included things like contracts and communications with talent agencies, yada, 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 all these kinds of things. And the social media post, it doesn't fall within that demand. It's not an effort to obtain jobs. It's just a grievance that was posted on Instagram. This argument as well, this is to me it's just classic civil litigation. Okay, arguing about why I didn't produce this thing, why I think it's not within the scope. It's all such bad faith. You knew you wanted to make this argument, and you just wanted to hide the ball and try to get it in by ambush so that they wouldn't be able to contradict it. And so, you know, it's hard for me to kind of weigh, does a judge take this kind of argument seriously? Because I certainly don't. I really don't. I'm like, only if you look at discovery as a sort of game, you know, that you're trying to play to produce as little as you actually, you know, can justify, and get away with not producing stuff that ultimately ends up playing an important part of your case at trial. It's just so bad faith that I have a hard time kind of sympathizing with that and really relating to how somebody like this judge, who comes out of the civil background, might have. You know, they might see that as normal, and just kind of part of the risk of civil litigation and discovery. You got to be careful about how you phrase your demands and stuff like that. I really don't know. It's hard for me to assess how an argument like that lands with the judge. With me personally, I you know, thought it was kind of ridiculous. And the bottom line anyway is that I don't think the complaint was that she didn't produce this Instagram post. They're clearly able to keep track of her Instagram posts. They know what she's doing on Instagram. The issue is substantiation of her claim. Where are the offers for the 20 jobs that you say that you lost? Where are the you know, where are the emails or notifications or whatever that those offers were being rescinded? What's your basis for making the connection between that and this domestic violence restraining order? The proof of the income, you know, is just very conveniently kind of whipped up out of nothing. She barely makes $50,000 a year anyway on these conventions, according to her own calculations. So 50 to 60, you lost as much as you made. You should be able to substantiate that. But obviously there was nothing. And that's really what the complaint went to, because the communications with the agents and the contracts and so forth, that's why you're asking for that, is to be able to establish that kind of claim. So the judge interjected at this point. He wanted to know, well, was there evidence of contracts and communications and the things that were requested? Was that produced, and, you know, was it submitted during trial? And the answer to that is no. And the judge says, well, that's kind of what her burden goes to, and that's what the document request is going after. He says this email, this Instagram post, this is her saying it, but that's not enough. So already getting kind of a preview, pretty clear preview. This factor isn't going your way, Alice. The judge isn't buying that you have established sufficient cause for him to find that you're, extremely burdened by this DVRO. So Janina then turns to the being detained at the border when she travels internationally, which is required for her to work, and it frightens the kids, and the kids are frightened that she would end up in jail. And Alice had testified about this phone call that she claims Ioan had with the oldest daughter about her going to jail, that, mommy's in jail, and, she's, and the daughter's saying, no, she's not, she's right here. And then he says, this is all allegedly, because I don't buy this. And Ioan denied it. He denied that this phone call happened. But then that Ioan said, oh, well, she will be soon. I don't buy this for a second. But Janina goes back to that. Another issue that Janina points to is that if the DVRO is extended permanently, then the children are going to have to be in a position to choose which parent attends important events like graduations, weddings, stuff like that. And there's no opportunity for healing. No opportunity for healing. The whole push and pull of this abuse dynamic is just something that has been severely under-addressed at this trial, in my opinion, because that's been the hook the whole time. Here you can have your kids know I'm going to yank them away. Once once I yank them away, I'm gonna beat you with, oh, you abandoned them, you left them, you won't talk to them. And it's this using reunification as a weapon. It hasn't gotten significantly, just the treatment that it really warrants in this case, because that has been such a huge part of Alice's abuse campaign, is how she has withheld the children, offered the children. She has tried to keep him on the hook with hope that he'll be able to restore that relationship. And then she gets her satisfaction out of crushing that hope. So it's that cycle. It's like an addictive cycle that she's trying to perpetrate. And that's very much mirrored in this consideration here. Oh, no opportunity for healing. That's because he's past that, because of your abuse campaign. And having recognized this cycle and the risks that it presents to him in all kinds of ways, okay? There's the false accusation risk and all of that type of thing, just the getting dragged back into the conflict risk. But then there's also just the emotional risk of getting your hopes back up again and then getting them disappointed, because guess what? Nothing has actually changed, and there is no real healing with somebody like this. So really wish that particular issue had gotten a little bit more airtime so far in the trial. She then points to Bianca, but Bianca anyway posted, look at what she did. Look at what Bianca did. She posted on Instagram calling Alice an abuser. And that was with Ioan's full knowledge and support. That is not what the testimony was. She said he really had nothing to do with it. It was kind of her call to do it. And she referred back to the case that she really wants the judge to rely on, where, the respondent did everything right and the respondent was more credible and yada, yada. And in that case, the judge's finding denying the renewal, that included a finding that the petitioner had used the DVRO to defame the restrained party. And in this case, Bianca's post is derogatory towards Alice, but then Ioan did even more derogatory stuff, but it's more covert because he put it in his renewal request. if this isn't the pot calling the kettle black, if this isn't the pot calling the kettle black, Alice for years has been putting all these fake, untrue, false smears in her legal filings, which then get picked up and reported on by the Daily Mail. And now she's complaining that comes back on her, that Ioan makes a claim in his DVRO renewal application, and she doesn't like it. She says he made the cocaine claim that he knew the press would pick up, and that just begs the question about his true intentions for the renewal. So first off, this is misusing begging the question. This is one of my pet peeves. Begging the question does not mean raising the question. This is not synonymous. Begging the question is making a circular argument. This is a, I don't know, thing you learn in philosophy, type of fallacious reasoning. Begging the question is making a circular argument where you are assuming the answer in the question that you're asking. But ultimately, she's just saying this this goes to, oh, he doesn't even really want this order. He's just trying to get back at Alice, which we're back at the projection. Alice uses litigation abuse, so that's what she thinks that Ioan is doing. And that's what she wants the judge to think that Ioan is doing. And I thought this was really funny, because this is more or less how she concluded her argument. Even despite that, he filed this renewal and it had these terrible claims, but you know what? Alice didn't post about it. She didn't post about it. So that shows she's grown and changed. Alice didn't shut the fuck up for years. And Alice crowed every time there was something in her favor in the press. And then this thing that's, pretty not favorable to her, really makes her look bad, gets picked up, and she's quiet about it. And that's because she's changed? No, it's because she's hoping it goes away. It's because she can't respond to it in a way that isn't going to violate the DVRO. And she wants it to go away. If she says something about it, that's going to just put it back in the news cycle. It's going to create a whole new round of people talking about this accusation. It's not Alice has changed. It's Alice is quite cunning when it comes to her publicity kind of management. Like, she understands this stuff. She may not be all that good at it a lot of the time. She may not have a particularly good ability to promote a positive public image, but I don't know that matters to Alice. My sense is that she has a bit of a any publicity is good publicity kind of attitude. That said, this one is obviously pretty beyond the pale, particularly when she's kind of trying to position herself as, mommy of the year. She's great mommy, and this tends to undermine that. So I don't think it's particularly proof that she's grown and changed, but that was going to be Janina's argument. So based on that, we don't think you should renew it. Definitely not permanently. If you gotta do the minimum 5 years, but we think there shouldn't be a DVRO at all. So then we had the rebuttal from Joe. This started off with he told the court yesterday there had been a little bit of an interruption in discussion during his closing because he had raised a social media post that Alice made where she had a bad attitude about parenting classes. And so they had located that. He provided the citation. It was Exhibit 71 at page 52, and that is in evidence. They corroborated. So Janina interrupted at this point to say, well, the argument wasn't about parenting classes. It was the argument that she had opposed the reunification therapy. And the judge said the whole issue with therapy came in through Alice's testimony, and the parenting class is her post that she made. And Janina said, well, but the issue, we had taken issue with was the lack of cooperation with reunification. That allegation was not in evidence. And the judge says, I didn't hear it in evidence. And then he wants to know, did anybody order reunification? Did anybody order reunification? And Janina said it was stipulated. It was one of the stipulated orders that they did. And the judge says, so first off, I'm like, I guess maybe the judge hasn't read the file. I guess maybe he hasn't read the file, because it's definitely there in the file. And it's kind of an important part of this case. It really changes the situation, I think, pretty significantly if the judge hasn't read the file and doesn't know this background. It really puts in a very different light what needs to be brought to his attention, and what can you just assume that he already understands and he already gets. I had been kind of working under the assumption, new judge gets the file, he's going to read the file. But it seems that's maybe not the case. And he really maybe does need to have his hand held about the entire course of events that has transpired from the very beginning when it was filed. So the judge says, after Janina says it had been stipulated, he says, I'm closing my ears because I would not have ordered that in a DV case, because it can be a dangerous situation to have them all in the same room. And Janina clarifies, it wasn't like that. The reunification was with Ioan and the children. And the judge is like, nevertheless. So the judge wouldn't have ordered reunification because of the domestic violence. I want you to file this away in your minds. Okay, remember that he said this, because we're going to come back to it when we get to some other comments that he made that to me are quite troubling in light of this particular comment, this observation, which seems to reflect a fairly sophisticated understanding of domestic violence and the difficulty that it presents when you're dealing with parenting. You cannot co-parent with an abuser. You can't co-parent with an abuser. This is going to be contrary to the advice of pretty much like most therapists and people like that are trying to like help you deal with having been in an abusive relationship and recover from it and develop better patterns and so forth. That's extremely important to, if possible, cut off, and if not possible, minimize your contact with the abuser. And so in situations where you have children in common, they typically will not recommend that you try to classically co-parent. What's kind of the trend now is they recommend what's called parallel parenting. And parallel parenting is much more along the lines of you keep boundaries in place, you keep communication minimal, you keep it through these monitored contacts like the Our Family Wizard and so forth, and otherwise you just you sort of independently maintain your relationships with the kids. And the problem is that that's exactly what Ioan was trying to do for years. Made that effort and couldn't do that. She couldn't stop abusing him on the Our Family Wizard. She couldn't stop denigrating him to the children, perpetrating the alienation, interfering with the therapy, and so forth. She just couldn't. In her own daughter's best interests, in having a good relationship with their father, she simply could not, put their interests first and encourage them to do that and do what needed to be done to try to deal with the, effects of the split and so forth. And it's understandable that kids are affected by things like that. And that is exactly why kids should be in therapy. Kids should be encouraged by both parents to, have a good relationship with the other and so forth. If the children themselves are not victims of abuse, then it's going to be in their interest to have, continued relationship with both parents. So this comment seemed, kind of insightful. Like you don't argue. There's certain things you can't do in a domestic violence situation because it changes the ground rules and it changes the risks of what's at stake. And so later on though, really let down by some of the comments that this judge made. So remember that. Joe started then with Janina re-arguing. He says she re-argued events that preceded the DVRO all the way back to July of 2020, an event that Ioan didn't even raise in his direct examination. And I have to question why the July 2020 stuff is what he raised in the renewal. He raised it as this was the reason why I left Alice. She has been smearing me publicly as an adulterer and claimed that that's why I left the marriage. Here's the actual reason why. This incident where she offered cocaine to the kids, she physically abused me, she passed out drunk on the floor. I had to go to Australia the next day. She, on FaceTime threatened to accuse me of causing this big bruise on her, threatening to make a false accusation of physical abuse. These were the incidents that led him to conclude the marriage was over. It's not retrievable. This is broken. You cannot continue in a relationship with somebody who is doing and threatening things like this. So that's why he raised it in his renewal. But Joe is arguing he didn't raise it in his direct. So why is Janina even going into this? It's not in the scope of the DVRO hearing to relitigate abuse that preceded the hearing, and says that it's improper to ask for findings on that. The judge interjects and he says the point was that those incidents were in his renewal application. So they're at issue, but they weren't part of the original hearing. And Joe says, well, there could be a number of reasons why the initial incident wasn't introduced at the permanent restraining order hearing. There was already more than enough evidence given Ellis's voluminous communications. And so could have been in previous counsel, could have made the determination that it didn't need to be raised. Another just gap. Another missed opportunity in terms of the explanation. This is like a strategic explanation. This is kind of making it sound like you're admitting this was a sandbag. And that's not good. That's not good. Courts don't like to be sandbagged with stuff. And so the court never got an explanation really other than Ioan had explained she threatened to accuse me of doing the worst kind of abuse to the children if I disclosed these things. That's what needed to be brought up here. This was part of the abuse. That's why he didn't bring it up. He was still terrified of this woman and what she might do and how she might take steps to ruin his life. With an accusation like that, that's not only going to affect your career and your public image, but could end you in prison. Maybe that's why he didn't bring it up. That's what he said. But they left it in these strategic terms. And I think that was a huge mistake. Janina spent the next 20 minutes of her argument contesting Alice's violations of the stay-away order. And this underscores Alice's lack of contrition. She is still denying and making excuses for her abusive behavior. She can't have it both ways. She either needs to take responsibility and move forward towards making real change, or continue with her denial and excuses. Starting with the parent-teacher conference, Alice claims that a series of coincidences led her to barging in to Ioan's parent-teacher conference. It's not credible. She acknowledged there was a history of a sign-up sheet. She knew about it. She wasn't even on the sign-up sheet. In her deposition, she claimed she had an appointment scheduled after his, but he had the last scheduled appointment for the day. But then later, she claims she mixed up and arrived early, but that's inconsistent with her apologizing to the teacher for being late. And also with the teacher's instruction for her to leave, because if she had been late, she would presumably be allowed to attend, wouldn't she? I mean, she's there. Also, her claim that she didn't recognize Ioan when she, walked in, and he's sitting right here, and the judge interjects and says Alice said that she saw the back of his head. And that's why she didn't recognize him. Ioan may have said differently. And Jo continues, it's also unclear if, from her testimony, if she was there to pick up the kids or if she was going for a parent-teacher conference that she hadn't signed up for, because she's given multiple explanations. He says it's highly implausible that she just blocked the egress from the main door. More likely than not, she learned about the appointment by looking online and then showed up. And this is consistent with her pattern of power and control. Then the Beverly Boulevard incident. Ioan and Bianca both testified consistently about the incident. They had video of the incident. Alice claims that it's impossible, but she never really explains how Google Map photos from years later prove that she didn't do what she saw on video doing. And her claim of coincidence here isn't believable. She denies that she flipped them off, but we had testimony from Iris Braden that she did the same thing with the girls, to Iris and Bianca. So her, claim that she never did anything like that isn't credible. Then the photograph in the courtroom incident. He says, Judge, the bailiff announces in that courtroom every single time before a court is in session, and there is a sign that says not allowed to photograph. The ignorance of the law is not probable in this case, and there's no argument anyway that she didn't know about the stay away order. So even if she didn't know you're not supposed to photograph in the courtroom, she knows she's not supposed to photograph him, period. She's supposed to stay away from him and not stalk and surveil him with photography. Then he turns to Janina's arguments that Alice's social media posts, they have taken on a better tenor these days. And he says his response to that is that there is no de minimis violation of a DVRO, and she has multiple violations every year. And at the end of the day, there is no excuse for domestic violence. So his final comment, the standard is simply whether Ioan and Bianca have a reasonable subjective fear of continuing abuse. It's not about Alice or her self-serving excuses for the 5-year smear campaign. It's not about whether she, through the course of slinging mud, got some of that mud splattered on herself. Her problems are self-caused in that respect, to the extent that she's had harm from the DVRO that is self-caused, and they are insignificant in comparison to the harm that she has caused to Ioan and Bianca. Bianca had testified about the death threats that they've received in response to Alice's campaign. The income and expense, he says the income and expense he's referring to is her 2026 one. It wasn't clear to me if Janina was like reading from the wrong income and expense. I don't know. It seems to be a standard form, and she was pointing out the question, but anyway, he just points out the income and expense that he was referring to is the 2026 one. Bianca's post that she made, her Instagram post, was in response to Alice's social media posting and an attempt to correct the public record. So if there are findings to be made, here are the areas he asserts that show Ioan and Bianca have met their burden of proof. 1, fear has been reasonably engendered by Alice's purposeful and relentless campaign to harm Ioan economically, to damage his career, to hurt his public image. And it's all still on the internet, along with the media coverage that it engendered, and it remains a source of abuse to this day. The fact that she did it, she can't undo it, and he is still, getting public abuse as a result of that. The fear that they have comes from the threats from Alice's followers that imbibed her poison. They imbibed her poison, and they go out and they re-spew it elsewhere in the world. Their fear is based on the many abusive communications and social media posts that resulted in the permanent restraining order in the first place and are still out there with articles about them. It's based on the duration and extensiveness of the campaign. This has gone on for 5 years. So it's not like it was a, flash in the pan and then everything has been hunky-dory since. This has been ongoing, persistent, relentless for years. It's based on her many violations of the temporary restraining order, the permanent restraining order, and other court orders throughout the 3 years that the PRO has been in place. It's based on the unremediated damage that her posts and articles caused them, and the unremediated existence of those posts and articles, by which I think he means she's never recanted. She's never apologized. She's never said, I was wrong. She's never tried to rehabilitate him publicly. Be very simple thing to do. Very simple thing to do. You want to talk about opportunities for healing, that's how that door would be opened. But she's never done that. And frankly, I don't think she ever will. And lastly, Alice's less than convincing show of sorrow and her failure to remediate the harm shows that she has done nothing to allay the fears of continued abuse. She has words, but she has no actions. He says change comes when somebody recognizes and admits the problem. But that has to be followed by stopping the behavior and fixing it. True remediation requires a full public confession of her untruthful claims. That hasn't happened, and it probably never will. I agree with him on that. And it also requires a long history of changed behavior. But she has continued her conduct up into the recent period. Ioan and Bianca have credibly testified. They presented documentary evidence in their support. And so for that reason, he thinks they have met their burden to get the renewal. So the judge now asks, in the renewal request, you had said you wanted a permanent order, but now he made, I didn't write down exactly where he said it. I think it was right there in that closing. He said, at least a 5-year renewal. And so the judge says you'd previously asked for permanent. Now you're saying maybe 5 years. Do you have a position on that? And Joe says, I think 5 years is appropriate. He says, I think 5 years is appropriate. He didn't ask for the permanent order. He asked for the 5-year order. He got exactly what he asked for. He says if she takes the small momentum that she has and moves forward, then perhaps there can be some progress. But if not, I guess we'll be back in 5 years. I like Joe. I don't dislike him. I don't always agree with him or his strategy, certainly. But this is the kind of thing that honestly, it seems a little bit more in the lawyer's continuing employment interest more than the client's. It's not in Ioan's interest to come back in 5 years. To have to do all this over again. I mean, what's the likelihood he gets a fee award that Alice pays it anyway? So he's going to have to incur more expense, do this all over again. Because realistically, is Alice going to change? Is she gonna finally give that apology? I don't think so. I really don't. I would love to see it. You know, Alice, I know you're watching. Shut me up. I would love to be wrong. I would love to be wrong. Shut me right up. Do it. Do it and shut me up, because I know you're fucking not going to ever. She's so dug in. So absolutely dug in on these lies and on this mission that he must be a bad guy. He must be seen to be a bad guy in every corner of the world. And she's not going to let that go. I would love it if the reason why the Daily Mail hasn't published anything yet about this renewal is because Alice is busy writing her apology. I would fucking love to be wrong about that. I just don't think I am. So, coming back in 5 years, I really don't know. I really don't know that that's exactly in Ioan's interest. However, I do understand from a strategic standpoint, it's one of the challenges that you always face in court. There's what you want, there's what you can get, and there's what's going to make you look best with the judge. And certainly reasons to think that, look, if we just take the high ground, we'll have a better chance of getting what we want. It does tend to undermine, for example, some of these arguments that Janina has made, that like, oh, he's the one that's engaging in the litigation abuse or whatever. No, like, we're actually just trying to be reasonable here and protect his safety and give her a fair shot. She should have already, I mean, she's already had 3 years to change her ways, couldn't do it. But sure, we'll give her another 5, I guess. So, yeah, I don't necessarily love it. I don't necessarily think it's the best thing for him, but I do understand why strategically that could be the smart thing to do. And at the end of the day, it does mean he wins because he got exactly what he asked for. He got the 5-year order. So both of them, the parties then confirmed they had submitted on the issue. So we went off the record briefly, and then we came back for the judge to read his ruling. I have 12 pages of notes here that are just the judge's ruling. So just to give you a little bit of a preview of how much the judge had to say here. It was quite a lot. He started off by apologizing to both sides because he says, I'm going to do my best when I get to the evidence, but I've made so many notes from the exhibits and your arguments and all this stuff, so it may sound jumbled and out of order. I've tried to capture as much as I can. The findings aren't going to cover every single piece of evidence, but I'm just going to do my best to give the overview. So he starts with the statute, Family Code 6345A, which is the Domestic Violence Protection Act. He says it's very short. It's the statement of intent. And he commended both counsel in the case for steering away from the quote unquote common notions about what's required to renew a restraining order. For example, you don't have to prove a violation. It's not required to prove a violation. His options are either 5 more years or more or permanently. That's the limit of his discretion, but he does not have discretion to go below the 5 years. That is the minimum term for the renewal. There's no showing of further abuse is required. The standard of proof is preponderance of the evidence. And if the court finds that he has met the burden, he is entitled to relief. The lead case on this, as everyone has pointed out, is Ritchie versus Conrad, and it states that the renewal should occur if the protected persons show a reasonable apprehension of future abuse, meaning would a reasonable person fear repetition of the abuse if the order is allowed to expire? He clarifies, though, something rather interesting and not at all intuitive to me, that this particular reasonable person standard isn't objective. It's not an objective standard. This is not intuitive at all, because that's like one of the first things you learn in torts in law school. Torts is like all about reasonable person standard. And that is meant to be objective. Just a standard person who is, not biased in any particular way, doesn't have any, particular peculiarities that would affect their reasoning or anything like that. What would this reasonable person do? What would this reasonable person perceive? And so it's meant to put yourself in the shoes of this, hypothetical reasonable person to make that determination. But that's not what you're doing here. He says there's case law that says it's actually not objective. It is merely the subjective perspective of the protected party. And so in this case, much of the testimony that he heard from Ioan was coupled with how he had felt about the communications that were being sent, and same with Bianca, and that all went to the assessment of their subjective fear. It really, it doesn't make sense. It doesn't really make sense to me that you're saying it's reasonable, but it's subjective. Because if it's just subjective, then literally all they have to do is get up on the stand and say, I was afraid. And then, I suppose this reasonable person standard is kind of substituting for a credibility determination. I don't believe them. I don't believe they're really afraid. So therefore they haven't met their burden subjectively. But why not? I don't know. It's just, it doesn't really make a lot of sense in terms of how reasonableness ordinarily operates under the law. But California can be a little strange with some of their reasoning, in my opinion. None of this is as weird as the whole Marilyn Manson thing, where like she, he couldn't use the fact that she had created the false FBI letter. She forged a false FBI letter that claimed there was an investigation against him for trafficking, and used it in her divorce case. And it was part of the decision throwing out his defamation case against her, that he's not allowed to use that because she denied it. She denied it in the anti-SLAPP context. All she has to do is deny it, and then it's not like criminal activity. It's not perjury as a matter of law. Bizarre, very bizarre legal reasoning from my perspective. So this isn't quite that weird, but sometimes California is a little weird. He cites to the most recent decision from 2004 out of the 2nd District, where LA sits, which is GG versus GS, in which the 3 Ritchie factors are outlined. First, the underlying factual predicate. Most of the evidence that he heard in the case was on this particular factor. 2, the existence of any significant changes since the DVRO was issued. Have the parties moved on, or has little changed? And this is more than just asking, did somebody violate the order? Then lastly, whether and how much the domestic violence restraining order burdens the restrained party. And he says there was significant and persuasive information on this point. So first, on the factual predicate, the court looks to the Domestic Violence Prevention Act, including its purpose, which he's said before. It's to create distance and space between the parties so that they can work on the underlying problems and root causes of the abuse. And that's because it is in the best interests of children primarily, but also the parties themselves, to prevent violence by cutting it out at the base, the reason why it's happening in the first place. He cites a couple of cases that state there is no distinction between physical and non-physical abuse in this context. So it does not matter if there is no police report. It doesn't matter if there's no photograph, and it doesn't even matter if there is no corroboration. Testimony alone can support a finding of abuse. In making this evaluation, the court weighs and considers the totality of the circumstances with non-physical abuse. And there are factors, or maybe like definitions. I should have looked up. Maybe I'll look up real quick. Let me get the number here. It's the definition. Okay, I remember this one. It's the definition of abuse under the Family Code, section 6320. I'm going to go ahead and just share it real quick while we are looking at this part. This has the definition of domestic abuse in it. And so it includes all of these things. You know, impersonating, harassing, telephoning, making annoying calls, destroying personal property, contacting, directly or indirectly, mail or otherwise, coming within a specified distance, disturbing of the peace, and etc. And it's got a specific definition for disturbing the peace that he gets into as well. So that is the statute that he invoked at this stage. And he said that several of these behaviors were shown by the original and the original order, as well as the renewal application. So several examples of, the statute includes several examples of what can constitute abuse. So the court heard testimony about the reactions and the upset that were caused by several incidents of conduct by Ellis, both before and after the court order that fit within the definition of 6320. So both before and after the order was entered, she engaged in conduct that constitutes domestic abuse. These included threatening, harassing, annoying contacts by email and other messages, both directly and indirectly. Bianca is a member of Ioan's household, so there is good cause to include her in the permanent restraining order as well as the renewal order. As to other conduct, he notes that the disturbing the peace clause was written several years ago, and there was all kinds of debate in the legislature about how do you reconcile this with the First Amendment limitations. So they added a subsection to the statute, and there have been cases, many cases over the years that expanded these definitions because of clinical studies, education of judges and attorneys about coercive control, and making it clear that abuse is not just hitting somebody in the face. It's not just like, oh, we're in a custody dispute. Coercive control has a fairly specific meaning as far as the type of conduct that it relates to. And California is kind of on the cutting edge, so to speak. Washington also recognizes coercive control as a form of abuse. In fact, in Washington, within the last year, we just had a decision come down out of the Court of Appeals where somebody applied for a domestic violence restraining order that was based entirely on allegations of coercive control. There was no allegation of physical threats, certainly, but it was largely things like monitoring and not allowing to go out with your friends and looking through your phone and stuff like that. And the court in Washington found, yeah, that's sufficient. That justifies a domestic violence restraining order under Washington law. Interesting. Might be swinging the pendulum a little far. I don't know. I think there's possibly some room for debate about that, but point here is simply that California as well recognizes coercive control specifically as a form of abuse, and so it is enough by itself to support the renewal. That is defined as conduct that based on the totality of the circumstances, the disturbing the peace, I'm sorry, is defined as conduct that based on the totality of the circumstances destroys the mental or emotional peace of a party. And that can be achieved directly or indirectly through a third party. It can be in person, it can be online, it can be through some other form of communication. Coercive control is a pattern of behavior that in purpose or effect unreasonably interferes with a person's exercise of free will. It can include things, he goes through all of these factors and then talks about how they apply or don't apply in this case. Isolation, including from friends or from relatives. He says that appears to apply in this case because the conduct isolated Ioan from his children as well as from his business associates. Depriving of basic necessities, a form of coercive control. He said that one doesn't appear to be at issue in this case. Controlling, regulating, monitoring the other party's movements and behavior. There was evidence showed both before and after the DVRO was issued that Alice engaged in these control and regulation and monitoring efforts towards Ioan and Bianca. There is overwhelming evidence to this, both before and after the order was entered. Compelling the other party by force, threat, or intimidation, including threats concerning someone's immigration status. Oops, in order to control their behavior. He says it is not free speech. It is not free speech to be saying Bianca has no green card and to be trying to use that to harm her. That is sufficient in and of itself for a permanent order because that is harassing. Coercive control can also include reproductive coercion, but that does not appear to be at play here. He says the statute is meant to educate the public, the bar, and the bench of the growing understanding of abuse. Practically every argument that has been advanced to justify abuse has been addressed at some point by the legislature, such as that if you use coercive control, it's abuse. You know, used to think unless you hit somebody, it's abuse. Wrong. He does this big wrong. You have to have corroborating evidence. Wrong. So the legislature has addressed these tropes that we talked about. He says, now he moves on to a very interesting exposition on the First Amendment. He says, I heard Alice argue that some of her speech is First Amendment protected. The First Amendment, of course, one of our most cherished rights, is not absolute. And it's also been addressed in the emotional abuse context. He cites a case that apparently dealt with some type of First Amendment claim that pertain to emotional abuse. There are certain utterances to which the First Amendment doesn't extend because they aren't part of the social exposition of ideas, and the benefit is so little that it's outweighed by the harm that it inflicts. That was the language from the case that he's referring to. He says the First Amendment imposes a responsibility for speech and behavior that is responsible and respectful in the social interest of order and morality. Now, actually, the First Amendment protects things like fuck the draft. The First Amendment does not require you to be nice. It doesn't require you to be respectful. It doesn't require any of those things. However, there are certain things that come up in these contexts that take the First Amendment out of play. One is when you are dealing with a course of conduct. It's the fact that the language is unwanted. It's the fact that the language serves no legitimate purpose. And it's the fact that the language is intended to cause some type of disturbance, some type of harm you know, even if just emotional, to the other party. Specifically, when it comes to like the First Amendment case law itself, it's the intent of the speaker that has been relied on to sort of justify restraining it in these types of contexts. The other issue that is going to come up here is always going to be the best interests of the children, and because it just that gets a very, very strong weight in family court, and so speech that is of a type that is likely to harm the children, the courts are going to restrict it. They're not going to say, oh yeah, of course you have a First Amendment right to say abusive things to your children. No, because they're going to look at the effect that it has. So really don't agree with the judge's characterization here that, you know, by having the First Amendment, you have a duty to speak respectfully and stuff. No, actually, there's Cohen case is the one that says you can say fuck the draft. You can say all kinds of things. In fact, the whole reason we have the First Amendment at all is to protect that fringe speech, because that's the stuff people don't want to hear. It's the stuff that's hard to protect. Respectful speech is easy. Nobody is going to be challenging that. So the First Amendment really exists for the fringes. He said some things came through, some arguments came through in this case that are disturbing to this court, that it's okay to say these things when there are children involved. He says people involved must choose whether speaking or not speaking is the better child-centered course of action. So he's in this context looking at it as a course of action, not so much you know, we're not going to say you can't say specific things, specific conduct-based things, but you can't hurt your kids. And so if your speech is likely to accomplish that, he's going to be concerned by it. And he says this applies whether you're a celebrity or a non-celebrity, because the law is the same for everybody. So just because you think you're famous and special, it doesn't mean you are exempt from the same rules that everybody else has to follow, and the same considerations, and the same just practical reality that abusing your spouse harms the children that you had with that spouse, because they have a bond with that spouse, and you are damaging that bond. And so that's part of going forward. Has there been a reckoning? Has there been real responsibility taken? Have measures been taken so that it won't happen again? In this case, the court appreciates counsel's briefing. They provided a treatise on renewal, lots of cases that the court has relied on. And so now turning to the evidence itself, that was all legal exposition, the principles, the background, the context of the law that's going to apply to this particular situation. Now we turn to the evidence itself. So Mr. Langlois cited to the original request for the domestic violence restraining order several incidents that it contained. Also the supplemental declaration from back in 2022, it contained several examples of conduct from before the restraining order. I'm sorry. We start with his original application that included certain incidents, but then his declaration in support of the renewal is what he's talking about. It included several examples of conduct from before the restraining order. He says, I agree with Alice's argument. This isn't a case of physical abuse. There is little to no evidence of physical abuse. So we just got done saying you don't have to have corroboration. Ioan testified to it. But that's not going to be enough. Not going to be enough when you have a man. That's alarming to me. I would agree it's minimal. He's only testified to this one particular incident. Didn't go into a lot of detail. And so it looks like the judge is kind of holding that against him. Kind of dismissing it. And, you know, this goes to what was really bothering me yesterday when I heard the closing argument. The judge has said all of these things that sound like he's got a very, you know, sophisticated understanding of domestic violence and the dynamics and so forth. But the healing from it, the readiness to be able to raise it and talk about it and deal with it, particularly in public, by somebody who is extremely private. This guy has yet to say a single word publicly about any of this. You know, it just that didn't get consideration here. It didn't get consideration here. It's unfortunate. But bottom line, he says he agrees, little to no evidence of physical abuse. So apparently he does need photographs, hospital records, because his testimony wasn't enough. After you just said you don't have to have corroboration, but with him, I guess you do. He says, I will make the findings that Ms. Verano had requested about the 3 issues because they do undermine Ioan's credibility, but only slightly. He says, under the law, the DV-100, the original application for the restraining order, is enough in itself. But it has been shown that this was intentional, deliberate, focused campaign of harassment towards Ioan and Bianca. It focused on his kids, his career, his finances, Bianca, her health, etc. Sometimes people do get in other relationships, and it's okay to be hurt by that, but the responsibility is to move on. Not fixate, not obsess, not seek vengeance. That's not the way to handle it. There are some who maybe have a darker purpose. Some of these people out there online that are, you know, part of this campaign, they might have a darker purpose and they might turn against Alice, and that's the risk here. So when one acts as Alice did, it causes more fees, it causes more costs, it causes more aggravation, more violence from others, and that is what happened here. She whipped up the mob. That was her intention, and that was what she accomplished. It was, in his opinion, absolutely shown adequately to grant the initial request. So as far as the predicate, very well established. He goes through some of the messages. One of the most instructive ones he thought was from April 17th of 2021, that she was dedicating her life to fighting him and using her social media. Ioan testified to the effect. He was disturbed, he was saddened. Another one that he reacted to from May of that year that involved a false public narrative that he described and caused him concern about how he would provide for his children. And then another part of an exhibit that was 6 pages, but they were posts that were all from one day. And he says that shows the relentless, concerted, and intentional nature of what she was doing. She was not letting it go. And so this ultimately created a culminated in the caustic social media campaign against Bianca's private health issues. He says it was disturbing to the court to hear Alice make an excuse for making those statements, that Bianca had talked about it first. Bianca disclosing it does not give permission to the whole world to harass her about it. And Alice directed specific emotional abuse and coercive control and harassment towards Bianca through her weaponization of Bianca's private health condition. The text about hiring a private detective to expose the private health condition disturbed him. There was also one reference to Alice's now deceased brother, and that included a threat of physical violence. I will effing cut you. I don't think it said effing. I think the judge did. I will effing cut you. He says it only needs to happen once to justify an order, and Ioan has met the burden regarding the factual predicate. The how's it going, want more after doing the interview, that shows, hi, Ioan, I'm still here. I know where you are. I'm still at it. And it was causing alarm and fear for his physical safety. Then there was a voice recording that he received. It had an aggressive tone. It reflected the fear that he had of her harming his career, his family, his relationship with the children. There was the threat in front of the children on February 1st of 2021, where the children reacted. At least one of them was upset by it. All of this is more support for the factual predicate. From Ioan's declaration, I'm going to Amber Heard you, referencing another celebrity case. If daddy is creepy with you, let me know about it. In this instance, he left the house. The daughter was upset. Alice was screaming profanity and obscenity at the top of her lungs. And this is harassment. This is what it is. One of the most persuasive and illustrative examples was the children talking to Ioan and what he is saying about the impact to him and how he's trying to hold it together for the kids. And this particular incident to the judge was especially disturbing because it's undermining his ability to support his kids by, earning an income. I don't know exactly what this was referring to. If this was like one of the recordings where the one where I can be daddy's therapist kind of thing, or if this was his description of the incident when it was after the visit, when Alice was freaking out and Ella was complaining that she said terrible things to Ella, and Ioan's telling her, mommy's mad at me, she's not mad at you, it just got directed at you, but it's not about you. Wasn't clear to me like exactly what this was talking about, but it was clearly had a big impact on the judge. Then the Our Family Wizard posts from December of 2021 to February 2022. There was a threat to use the nanny, a statement that things aren't going to end well, an implied threat to deport Bianca and commit a crime. And all of this is within the definition of coercive control and emotional abuse. So then we go to the renewal application, and he says, with the exception of the 3 incidents, the ones that preceded the DVRO, they repeated incidents of what had happened since the restraining order, the campaigns on social media to advance false narratives to his detriment. And he noted how they testified that eventually the cumulative effect of this entire campaign, it just exhausted them. So first, conduct before the restraining order turns to the post where Alice says, fuck it, I'm breaking it. That was when the TRO was in effect, but before the full restraining order was in effect. But she said that 4 times, and that left Ioan feeling helpless and unprotected. He said, this isn't all. It's just a sample of the most severe evidence that led to the restraining order. And Mr. Langlois was very eloquent. And he says, I identified what he inventoried in his argument. All of these different exhibits, pages, he repeated them. I wrote them down for when and if we ever get the exhibits. Maybe I'll be able to break this down a little bit more. So in conclusion, full consideration of the totality of the circumstances, that it's, there was factual predicate, and that in and of itself may be enough reason to extend the order in the case. So the second factor then goes to changes. There have been changes of circumstances. So he felt this was a very persuasive argument that respondent had made, but he doesn't follow it completely. So first, Alice testified that it was like another person. She felt like she was looking at another person who had written these posts, and that it wasn't her. And he says, well, but that's part of accepting responsibility. It was you, Alice. So you doing this whole distancing, it's not me thing. That's resisting accountability is what it is. You need to internalize that this is you and this is what you did. And that's what real change is going to require. He said her affect on the stand, the way she presented her tears and everything, it was remorse. He thought it was sincere and it was remorse. But he said it's not complete remorse because the behavior continued. And so it's just a good first step. Just a good first step. He is dismayed by her quitting therapy and by her blaming Ioan for not getting health insurance as the reason why she did not continue with that. He says it is incumbent upon Alice to get more therapy so that she will not re-engage in this campaign of denigration. She needs to instead engage on the perhaps more difficult course of self-examination. You think this is news to Alice? Honestly, that's like, this isn't news to Alice. Okay, people have been telling her this for years. She knows this. She knows this perfectly well. She doesn't want to. But I guess we'll deal with this again 5 years down the road, when Alice has still continued to not engage in any kind of self-reflection or take any kind of accountability, continues to blame everybody else, continues to victimize herself. I guarantee you her takeaway from this court hearing today is how unfairly she's been treated by the family court. How bad the system is. It's let her down so terribly. That's going to be her takeaway. Dave deprived me of my First Amendment rights. Yeah, it is a very difficult course of self-examination. And unfortunately, Judge, there are certain types of personalities who are resistant, isn't even a strong enough word for it. They are like immune to it. It exceeds their capabilities. It's not possible. So, yeah, I'd love to see it too. But that would require a different person and a different set of circumstances. And I don't think we have that. Prove me wrong, Alice. Prove me wrong. Shut me right up. Shut me right up. Make me look like the biggest asshole here on the internet. Do it. I dare you. I dare you. Prove me wrong. He said he believed it was heartfelt when she said she wished she could apologize to Ioan because it's clear they don't speak anymore, and this was like the only opportunity that she had to be able to do that. And he said it's very sad to this court that there are 2 kids involved, but Ioan doesn't have contact with them. The judge, okay, if nothing else happens in the next 2 days, the judge really fucking needs to understand the whole background here why Ioan doesn't have contact with the kids. Because yeah, it is really sad. It's extremely sad. And the responsibility for that needs to be laid in the appropriate place. He needs to understand how all this has come about. Because yeah, it's sad, but you cannot maintain contact with an abuser. He has no duty to martyr himself, his new wife, his new child, his family, his well-being, to her need for control and her willingness to weaponize the children and to use them in order to achieve those goals of harming him. So the judge needs a much clearer picture of that if nothing else happens over the next 2 days. He says, I know we've talked about this custody order, and the court has said I'm not going to sign off on it because it doesn't meet the law, but we're also not deciding custody because it's final. They reached a final agreement. But if it's ever modified, then this restraining order plays an integral part in it. It cannot simply be ignored. And so that's why he says this court isn't deciding custody and visitation. If the court was deciding it, it would be a very different trial. It would be a very different trial if he was deciding custody and visitation. So he kind of directly to Alice states he wants her to work on the root causes that go to her need to have the public involved in her business. He says the rest of the public has no business being involved in any of this. That's not an order, but it's just useful information. There were 4 claimed violations. He says first 3, he says 3 claimed, but actually 4 claimed violations from after the restraining order was issued. First, the parent-teacher conference on November 17th of 2022. He concludes on this one that Ioan did not show that this was a violation of the restraining order because it was the kind of confusing and fraught situation that parties get into by not communicating. So Ioan's supposed to still communicate with his abuser in this framework. He's seen all of these Our Family Wizard messages and her inability to stick with peaceful communication about the children. And he seems to be saying you still have to do that, or I'm going to hold it against you. He says Ioan had never appeared for the parent-teacher conference. He didn't communicate with the other parent as a joint legal custodian would. Alice likewise didn't communicate that she was going. Her explanation for how she signed up, I found quite implausible, you think? But he says, both being there, I don't find by the preponderance that it's a violation. It is an indication of the need for communication. You can use Our Family Wizard, and you have an obligation to do that under the stipulation. So I guess Ioan would have to give up legal custody of the children in order to be able to be free from his abuser in this court's thinking. I'm having a hard time with this one, guys. I'm having a hard time with this one. Because on the one hand, you just acknowledged reunification therapy in a domestic violence situation. You don't want to do that. You don't want to put all the people in the same room. You don't want to keep these doors open. You need to minimize contact. It's very important. But here you are saying you have a duty to communicate with this woman on Our Family Wizard who cannot control herself. She has demonstrated that repeatedly. Some of her violations relate to her use of the Our Family Wizard to send him more abuse. I don't see a situation where he can win here under this type of thinking. I really don't. It's a, you know, heads you lose, tails you lose type of situation. Cut off contact with your abuser, and it's going to be held against you. Or maintain contact with your abuser at the cost of your well-being. I don't like it at all. He says the best practice is to tell the school that you have the restraining order. They are very experienced in these matters. He also says it makes me very sad that there is this restraining order for all the reasons that were mentioned by Ms. Verano, the parties, the graduations, and things like that. He says there are ways to create exceptions for events, to carve out things for therapies and things that would be helpful and therapeutic. He says it's not an order, but I advise you to move forward this way and not on a public forum. The January 16th, 2023 Beverly Boulevard incident, however, was a violation. It was described by Ioan from his diagram and from his testimony, found it credible, less so Bianca, only just because she didn't see everything. It was not controverted that she passed by 3 times, that she made at least 2 U-turns. He says this is stalking, this is following, this has no legitimate purpose. It is just to get into the proximity of the protected party. He thought the testimony about the building and the impossibility of seeing whatever was a distraction. He says the court saw the video, and the last couple of seconds when Alice's car goes by, the court can hear plain as day, her car horn is beeping. That is a form of communication and intimidation. Here I am. Whether she middle fingered, you know, gave the middle finger or just waved in terms of her gesture, doesn't matter, because it's an offensive communication, it's intimidation, and it's a violation of the permanent order anyway. No communication, no direct communication is allowed. This is not peaceful communications about the children, which is the carve out that the order had provided for. Then the photography incident in Department 6 on September 9th of 2024. I feel sort of proud to have had my own role in the small measure of justice that's been done today. He says, I find myself in a minority, apparently, of reminding people that you can't record before court starts. He says there are signs everywhere. They are in the hallways. They are by the elevators. It is clear as day that you can't do that without court permission. And the idea, can I stand up in the middle aisle and take a picture of the opposing party? He says that's a violation, even if it's directed at the person behind him. It upset him very much in that moment in the courtroom. So he's finding that violation, even if you were just trying to get me, Alice, because we know you said in your own words, look, he was talking to her. He was talking to her. And then you tried to fucking stalk him and surveil him to try to be able to like prove that or something. As if it would be a crime, even if he did freaking know me. Like, the projection is so off the hook, you know, it really is, because she's got her little deal going with Allison Bischoff. And so she is absolutely terrified. Oh gosh, there's that Andrea Burkhart. Andrea Burkhart says, you know, not nice things about me because I see your game, Alice. I see the harm that you're doing and I call it out. Therefore, must be the same deal that she has going on with Allison Bischoff. It's so much projection. But yes, it was quite upsetting to him. I'm quite sure. So this was a violation. Shame, shame, shame. Shame, 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 Alice. Just couldn't control yourself, could you? He said, that brings us to a point of great concern. This is what he seems to be calling the 4th violation of the DVRO. The filing of a brief in the public court file that included evidence from the confidential child custody evaluation. He says there is a case called Enka where there were severe monetary sanctions for doing that. This is not good. Not good for him to be bringing up Enka. Right before trial, this issue came up, right? Because she filed a trial brief. It has this confidential stuff in it. So Ioan had filed a motion to sanction her for doing this. And this Enka case is the basis for that. And so in Enka like wasn't even this bad. It was a situation where they were at a third party's deposition, or they weren't even at, it was at the actual party's deposition, but there was another lawyer involved who was present for the deposition who was not part of the custody issue. And so at the deposition, the parent is questioned about some of the contents of the child custody evaluation in front of the lawyer who isn't one of the people that's authorized to have access to it. And that's what the conduct was. And the court sanctioned the attorney at the deposition for that disclosure. I think it was $50,000. Like it was a pretty good size sanction. In this particular case, he says, it managed to get out to the media. It's filed in this brief. It gets out through the media. And he says releasing this private information, even through counsel, can be harassing and intimidating. And even if there is a stipulation that the children, are to live with Alice 100% of the time, he seems quite unpleased about that brief. So I do hope they jump on that and they continue to focus on that, because we are just about to move into the financial stage for the last 2 days. And the focus of that, to me, seems like it really is the financial and the litigation abuse. And so it's things like this. He's already talked about how this conduct, with the DVRO drives up costs and things like that. So does the custody dispute that she interfered with. And so do things like using your trial brief as an opportunity to reveal confidential information that requires your attorney to have to, deal with that. So I do hope that this doesn't just fall by the wayside, because to me, this is the judge very clearly signaling he doesn't like this at all. And if he thinks that this was purposeful, I mean, it doesn't even have to be. It only has to be reckless under the statute. Then, yeah, I think he would consider a sanction, because this ended up in the fucking Daily Mail. This wasn't just a private deposition that got revealed to one person, one lawyer, a lawyer who has confidentiality, which just isn't one of the people that is supposed to be having access to it. This got into the Daily Mail. I think he's quite concerned about that. So I very much hope they don't let this fall by the wayside, because it seems to me to be a signal that sanctions are potentially on the table. He says this pattern of abuse is 5 years in length. It's preceding and after the restraining order. He agrees with the argument that it has abated somewhat. It's not at the same level of vitriol or hate as it was in the early days for the order, but it has continued. So on the second Ritchie factor, there has been some showing, but not a sufficient showing to withdraw the speech and the conduct from the public eye, that she intends to do that. And the effect of that on his new wife and child is they now have received death threats. So there are not sufficient changes to warrant denying the renewal. He does, however, agree with the request to make findings regarding the conduct alleged in the renewal application that was not part of the DVRO. He says it was not proven by a preponderance of the evidence. This included the administering the cocaine to the children, the physical assault on Ioan, and the threat to blame him for the bruise on the arm. He relies on Evidence Code 412. This is the rule that says, this is the one Janina referred to the other day. If there is, if you present weaker evidence of something when there is stronger evidence available, then that evidence is to be distrusted. And so he says the elements of the stronger evidence are not credible in the court's eye, and so he draws an adverse interest against Ioan under this code. I think what he meant by this is he's just saying, honestly, it really wasn't clear to me, because it's not clear if he's saying, like, do you think there's stronger evidence of these claims that could have been presented? Or is he saying because the DVRO relied on quote unquote weaker claims rather than, you know, these allegations, that therefore these allegations are to be discredited? I think that's what he meant. But that sure does seem to be inconsistent with, again, his whole kind of preliminary disposition of the law, that there's no distinction between physical and non-physical abuse. They all count. So how is one weaker and one stronger? He had a lot of documentary evidence of her emotional abuse. And that was frankly the conduct that he was primarily concerned with addressing at this point in time. Alice's, you know, administration of cocaine to the children had a lot more to do with, like, his concerns about the custody issue and the visitation and the way that she would weaponize them, because this was ultimately an early example of that. The context was he was leaving for Australia. She didn't want him to go. And so she's putting the children at risk to try to get him to, like, turn around, get off the plane or whatever, have to deal with it. It was an early example of weaponizing the children. That's how I understood this particular allegation. So I'm not really clear on the whole stronger, weaker part and what the significance of that is. But the bottom line is he's saying he doesn't think that they have been proven. He says, however, overwhelming evidence outweighs these three incidents that were inappropriate and ill-advised. He doesn't think they should have been included in the renewal application. Didn't bring them up at the wrong time, at the right time. Right? Right, DV victim, you have to disclose on our time frame, not yours. That's the message. The third and final Ritchie factor is the effect that the restraining order has had on Alice. He says he's seen at least the start of some reckoning and responsibility. It's heard and seen that Alice was taken by surprise by the end of the relationship. Well, he got snookered by that one then. And that thereafter, Ioan engaged in a new one, and she said that she lost her mind, and he felt that that was genuine and that was reflective. She lost her mind. To me, that's a lack of accountability. That's an excuse. I only behaved badly because I lost my mind. It wasn't really me. That is still distancing yourself from your bad conduct. That's how I see it. He says how she reacted can be understood, but can't be justified or excused. And Alice's responsibility is to change her situation. There is not sufficient persuasive information on Alice's loss of income and the effect on her. He heard general information, but nothing specific regarding jobs, resumes, rejection letters, etc. And as well, there was testimony from Lynn Blank that she wasn't taking jobs even before the DVRO. I think he meant from Marianne Mulcahy, the manager, but he said Lynn. He says she has had some ill effects from the DVRO, but these are the consequences for her behavior and for which she must take full responsibility. There, at some point, won't be child support anymore. There won't be, the property division will be resolved. Spousal support is still to be determined, but she needs to have a conversation with her attorney and consider that it's possible it won't be there for life. Needs to start making a plan. Talk to your lawyer. Need to start making a plan because this might not be available and the child support isn't going to last. Oldest daughter is 16, about to be 17, I think, 17 in September. Youngest daughter is 13, 12. He says, so there's not enough as far as the economic difficulties. The travel difficulties, he says, I found very believable. He said, I know that there are restraining orders, they're registered, they're put into the CLET system, and it's very persuasive that that type of thing would happen at the airport, but that is a consequence of the behavior and the decision to post what you did. At this point, the corrective measures to get to the root of the behavior is what it's all about. So he then considered the length of the renewal on the impact to Alice. He says it crossed the court's mind in its preliminary thinking that the order should be permanent. He says today was outreach by Ioan that things can get better, that it won't play out in the public eye. But if you don't take a different course, Alice, there will be another one after this one expires. So he's giving Ioan credit for that. We just want the 5 years. Don't need to ask for the permanent. Give her the opportunity to show she can do better. Take the high road. He did give him credit for that. I don't know if I agree with the thinking behind it. Don't think there's going to be a change. But 5 years is a long time. So it is possible. Maybe by then she'll be bored. She'll have found something else to have gathered her attention. I mean, who knows? A lot can happen in 5 years. So even if she herself doesn't develop insight, doesn't take accountability, et cetera, she may simply just, her life has changed enough at that point that she's no longer a significant risk of this type of thing. It's possible. He said the argument that Ioan made a statement to the child that the mother would be in jail. He says the court views this with a negative inference towards Ioan because you shouldn't say things like that to the kids. Now, this pissed me off because he denied that ever happened. And this is a classic. This is a classic. Alice making shit up and triangulating. This is exactly the kind of thing that Amber Heard would do as well. They would say, oh, this person is going to this person is going to that. He just saw her doing this in the Our Family Wizard messages with the nanny. That is what she does. She makes up shit and attributes it to other people, and it's lies. And he bought this hook, line, and sinker. So he is now faulting Ioan for something I don't believe for a second he ever did. And that plays a role in the circumstances of Ioan's relationship with his children. This is blaming him for the deterioration of that relationship when he fought for years. He spent everything he had trying to keep that relationship alive. And Alice wouldn't have it. She just wouldn't have it. She wouldn't take the kids to therapy. She would interfere with the therapy. She would interfere with the visits. I mean, we see what poison she was willing to inject into the public sphere. Imagine the poison she is dripping in those children's ears about their father. I didn't like this one bit, and it told me I don't think he understands the scope of the alienation. He doesn't understand. He knows that there's a custody stipulation, but he doesn't know why. And he may be under the like false impression that Ioan is happy with the situation. So I really hope they do some work on that to clarify that and get the court up to speed. Because that's a big part of the abuse, the litigation abuse, was the use of the children to cause this custody dispute. Cost them so much money, but it cost him the relationship with the kids. He also says, I'm really not sure why it's important to you, Alice Ioan, to have your life aired in public. This is an Alice problem. Okay, that is something that the judge clearly hasn't gotten either. This is an Alice problem. Ioan has not said a word. He has not said a word in public. This is Alice driven. Alice is the one who got the Daily Mail contract. Alice is the one who bragged, the tabs are on my side. Alice is the one who talked about making it a big public spectacle and then did. None of this is a Ioan thing. But here the judges both sidesing it. I don't think he sees this. He says, I don't get it. I'd advise you to attend to professionals who understand that you don't have to live that way, especially in light of the children, because of the children's involvement. I don't think Ioan needs that advice. I think he is, naturally abided by that. He says the court is familiar with kids coming out of high conflict divorces and kids compared to kids whose parents acted with dignity and restraint during the divorce, and those kids always would come out better, and they would, he would meet them and they would say things like, I'm so glad my parents worked together to have an amicable divorce. He says making the restraining order not permanent allows for the working on root causes so that you can all move forward. So based on the totality of the circumstances and the Ritchie factors, he concludes Ioan has met his burden by a preponderance of the evidence for renewal for 5 years from today. The court will prepare an order after hearing. The court has done so. It has been filed. It is of record now. All the more reason why it's just awfully weird that the Daily Mail, that was so interested in this trial of the year, hasn't had anything to say about it. Rather big decision. Weird how there's no news about it. He says, make sure that you tell the school, make sure you tell the local police. I'm not going to order mental health interventions. The lawyers can steer you to that in that direction. He says, I'm not empowered to make decisions about the kids, but there are ways to pursue that as well. Sometimes parents think in a divorce they need to win the kids. You think? But they have a duty and law to promote co-parenting, and you, Alice, have to find it. And you, Ioan, have to be patient to receive it. I don't like the both sidesing this at all. I really don't. Because parental alienation is not a both sides problem. It is an abusive, alienating parent problem. I don't like that this comes across as he's blaming Ioan for the status quo and for what he's had really no choice but to do. I don't like it. So he asked, what do we do for the rest of the morning? He says, he clarifies, I have no intention to deal with custody or visitation. If you can't deal with the stipulation, then we're just going to leave it out of the judgment. Janina said she's speaking tomorrow with custody counsel, and so that's probably what's going to happen. They'll just leave it out of the final judgment. Final judgment on everything but custody stipulation, and I guess they'll just run out the clock until the kids are 18. That's all I can think of. The judge advises Alice to read the order very carefully. He says it's very important. What it says has a lot of things about the consequences. It stays registered forever. There's no expunging an order like this. And he, wishes you the best. And Alice is, listening during this part and kind of, smiling and yes, wish you the best. Oh, yes, thank you. So the demeanor during this ruling, Ioan still head down for most of it. I think I just think he feels very defeated by this whole situation where even getting a win, and it is a win that he got today, it doesn't feel like a win because it's not satisfying. This hasn't protected him so far. I don't think he's got much expectation that it's going to protect him because he doesn't expect there's going to be real change. I think it's probably hard for him to sit there and take blame for the situation, for things that he didn't do, things that were lies about him, which means that it had the effect that Alice wanted. So I imagine that was very difficult for him to have to deal with today. Alice, for the most part, just sat kind of stony, sort of stony. She didn't have, big reactions. At the very end, there were a couple times when the judge would say things like, you need to change, you need to take accountability, and she would nod. She would like look at the court and nod. And to me, it looked, it looked performative. It looks like she's, still just trying to put on the show that like, yeah, I'm taking this real seriously and I'm taking it to heart and I'm really internalizing what you have to say. I just don't believe it. I just don't believe it. Prove me wrong, Alice. Prove me wrong. Make me look like the biggest asshole on YouTube. I would love it. I would love it. I dare you. I dare you. Prove me wrong. Show that you have it in you to have some fucking insight into what you've done and change and apologize and encourage your children to rebuild their relationship with their father and support it. Do that and make me look like a huge asshole. I'd love nothing more. I would be happy to be the bad guy in that scenario. But I don't believe it's going to happen. And I don't think Ioan does either. And that's why I think, that's what I think was reflected in his body language, hearing this order. So we took a short recess so they could decide what are we doing for the rest of the day. We ended up coming back in and they said, we're just going to call it a day. It's 11 o'clock. They're just going to come back tomorrow. So we did go over then what is left for the case. And it sounds like they have just 3 witnesses left, Bianca, Ioan, and Alice. He expects Bianca is going to be very short. He says he's going to do what he calls his 776. This was another one. I'm like, what is this? I got to look this up real quick too. California Family Code 776. 776 allows a party to a civil action to, let's see, may be called and examined as if under cross-examination by any adverse party during the presentation of evidence by the party calling the witness. It just looks like it's specific rules in family cases to where you can call the adverse party in your case in chief, but still kind of treat them as adverse. So it's like an exception to the normal rule. So he's saying they agreed that rather than calling her as on direct, and then having Janina call her separately in, in Janina's case, and then, cross-examination on that and all that, they're just going to do it all in one. And they will do that through cross-examination of Alice. So it means they'll call Bianca and Ioan and then rest. And then Alice will call Alice. Janina said there is a possibility of brief remote testimony from Diana Lesgert. So apparently she is not completely, out of the situation. What I was thinking that might have to do with is Janina had raised in her trial brief an issue concerning, she's arguing like her interpretation of the premarital agreement and her argument that the residuals are not excluded from the gross adjusted income available for support is because she's conflating them with royalties, for one thing, but she's saying royalties as a matter of accounting and tax law and so forth are not treated as passive income. And so it doesn't kind of fall into this passive income categorization that the premarital agreement also refers to. So that's kind of my thought, is she might be calling Diana Lesgert for that purpose, to just establish these are accounting issues, as distinct from legal ones that otherwise she's going to argue. But you know, I don't know. That's just a guess. It did seem like Patrick Green was pretty forthcoming in his exposition of the differences in their opinions. So she doesn't need to testify independently to lay it out, but they may want more explanation from her as to some of the details for those differences of opinion. So possibility now, so they do think they can get all of the evidence done by Friday. If we go all day tomorrow, all day Friday, they think they'll be able to get the evidence done, but not the arguments. And Joe said specifically, they want the transcripts before they have the closing arguments on this issue. And it takes several days for those to be prepared. So they wouldn't be prepared to argue on Friday, even if they were able to get all the evidence done with enough time to do that. So it sounds like the likely course of action at this point is that we will hopefully, if we can actually like realistically project time now, anticipate the time that these things are going to take, realistically get 3 witnesses done in 2 days, and then they'll set a date down the road for closing, and it will be after there's an opportunity for the transcripts to be prepared. So I may need to come back to LA for that. I don't know. We'll see. We'll see. See how that all fleshes out, and when they set it for, and what else is going on, and so forth. So that's the ruling. That's the ruling. It's a win, unequivocally a win for Ioan, but it really speaks to how unsatisfactory a win in the legal process typically is. Really is. You know, we call it a justice system, but that's kind of a fiction that we have, because far too often in these cases, by the time you're in court, there's no justice left to be had. What's been done to him and his relationship with his children is an injustice that none of this is going to remedy. The harm that he, you know, had to go through, the abuse that he had to suffer, the embarrassment, the public nature of all of this, none of this is making that any better. And like I said, I think he has every reason to not have a whole lot of faith that this order is going to be particularly effective in keeping him safe from more of the same, because it hasn't been so far. So why would it suddenly now? Alice has considered herself above the rules, I mean, for a long time. And so that's, you know, one of the often somewhat depressing things about following a court case is, you know, you're hoping for a big, just satisfactory kind of justice moment, and they unfortunately just don't really exist. They just don't really exist a lot of the time, because the harm is already done and none of this is fixing it. Even if he wins everything he's looking for, you know, on the financial side of things, that's not going to fix all of this either. All he's really doing is kind of mitigating the damage at this point. This is like a slow bleed. It's a slow bleed. He's trying to staunch it. Got a little bit of help with this DVRO, but the wound is still there. So And that's, not really, I don't know if it's an indictment of our court system. It's just reality. It's just reality, once that's been the point Joe has made repeatedly, that a lot of these situations, once things are done, they're done. And there's no going back. There's no fixing it at this point. So it's very sad. Well, we have one comment today. Lisa Loney, can't watch much on horrible divorces. Too painful, but you're looking lovely. Looking forward to other cases, perhaps medical freedom cases. Well, thank you very much. I understand these cases really hit home for a lot of people because this is not, unfortunately, that unusual an experience. A lot of people, very bad experiences in family court, very bad experiences, with breakups. They're kind of, by their nature, difficult, emotionally volatile, traumatic situations. And court system isn't really equipped to deal with them all that well. A lot of the same thing happens in probate when somebody dies. It's the same kind of situation. It's a traumatic, it's an emotionally fraught type of experience. And it just often brings out the worst, people's worst selves. And so, yeah, follow a bad probate, and like a lot of people will come out of the woodwork with their terrible experience that they had, when somebody died, and then somebody, was stealing from the estate or just causing problems, all kinds of things like that. So these are difficult situations, and yeah, often just no real justice, in the sense that nothing can really be brought right. And so for me, for what it's worth, this is why I put a lot of value on kind of just recognizing what I see as and call karma. I don't really mean that to have religious overtones, because I don't understand karma as a religious concept. I understand it as pretty straightforward. It's a cause and effect. Every decision, every choice. We exist in a world that much of it is beyond our control. We didn't choose the circumstances of our births. We didn't choose the nature of the world that we're born into. All of these things, the time period, the political context. I mean, there's just so much that is part of the conditions of our existence that we have no control over. And those have their own ways of self-perpetuating and moving forward that are also out of our control. It's I can't change the nature of biology. I'm just one vote in a big system. And that can leave you feeling, I think, a little helpless, if the world seems really deterministic and your influence is small. And I think you can often feel that way in the legal system, where so much of these things seem very foreign, and the laws are what they are, and the processes and all of these types of things. You don't really have control over that. And so I think karma is a very important concept in that framework, because karma is what you do have control over. It's that given these conditions that you don't have control over, you still do have your own will, your own ability to choose how you're going to move forward, what kinds of decisions you're going to make. And those are going to have consequences. Maybe not big ones, maybe just small incremental ones. But you know what? If everybody made small, incrementally good decisions moving forward, that would affect the totality. It would shift the whole totality in a more positive direction. It's the whole butterfly flapping its wings, causes the breeze around the world type of concept. So our choices do have those consequences. And When you make good choices, you bring even so slightly, a little bit more good into the world. When you make bad choices, you make the world ever slightly worse. And you know what? That's a world you have to live in. You are polluting the very environment that you need to occupy. And so you're contributing to your own suffering when you do that. Sometimes I think just karma is really the only real justice that I have it in me to kind of look for. The court system is at best a very imperfect proxy for things like justice. And I think this is this is a good example why. It's got to win, but is it really fixed anything? Has it really remediated anything? Has it really set things right? Don't think the system really has the ability to do that. 40 man, you've still got the knockout intellectual stamina I saw in Delphi. Well, thank you. Thank you very much for that. It's not having to put in nearly the hours I had to do in Delphi, so that probably helps. It's much easier to get into this court, and I get to have not only lunch. Not only do I get to have lunch, I get to have a long lunch. I get to have a luxurious lunch. I get to sit outside and get sun, vitamin D in this wonderful climate. It was so nice today on the way into court because I woke up and it was cloudy. It was like foggy, it was so cool and pleasant compared to like the heat it's been, but it's LA. It's not cold, it's just very, very comfortable for a nice little stroll. And then like around the edges of downtown, the fog starts to lift and you start to see the buildings peeking through, and you have that morning light glowing through the downtown. It was really a very, very beautiful day. So yeah, I appreciate the difference in covering a case like this versus the Delphi situation. But yeah, boy, talk about once again justice from court might be a little bit of a stretch. Might need to be looking in other areas for something satisfaction along those lines. Michigan Farm Boy, seems like a lot of these lawyers and judges don't have the insight we are getting from you with the psych background and experience you are bringing us. Your background in the case seems better than Joe's too. Thank you. I have been following this case longer than Joe's been on it. I mean, for that, for what that's worth. And I don't, Joe, I acknowledge, was never really part of this part of the case. He's not Ioan's custody lawyer, so he's not involved in that part of the dispute. He might not be that familiar with it. And he also wasn't originally going to be the attorney on this DVRO renewal. Ioan had hired a different firm to file the renewal paperwork for him. So to the extent that there is a admonishment from the judge about the prior incidents, including the prior incidents being like ill-advised, that is going to fall on this other law firm. And so they withdrew a couple months ago, I think, before the case got to trial. They basically came in and did the renewal paperwork and then got out. It's not clear to me why that is. But that's what happened. And so Ioan was originally set up to do it pro se. And then shortly before trial, Joe took it on. I think just in the recognition that, look, there's all this overlap and it's not going to make sense to try to like divvy out what's DVRO stuff, what's not DVRO stuff, because if he's making an argument that spousal support should be terminated because of abuse, then that's it all ties together. So I do think he might be a little bit new to it. He might not have gone into it as in depth as you know, not just me. There's a lot of people that have followed this case for a long time. There are people that, you know, follow this relationship. They know Alice's social media and her whole habits and everything like that far better than I do, because I was never a fan of either of these people. I remembered I was like, yeah, I remember 102 Dalmatians came out. Like that was pretty much my only frame of reference for them. And then Ioan's part in Titanic. I remember seeing that and recognizing him. I hadn't realized that was him. So I wasn't really following these people until this came up, and it just, you know, it struck me as another Depp v. Heard type of situation, but just one that you know, like, because kids are involved, it's just got a whole other level to this dynamic of this particular type of personality in a breakup that just isn't going to take any kind of accountability, refuses to, you know, look bad, and so sees the other person as just you know, something, a tool to use to try to build herself up in some way. Is like, as if it makes you, this is what I don't understand. Like, is it supposed to make you look good? That, like, you're saying this is, he's this big asshole, he's this terrible person. You married him, you picked him, you had kids with him. How does that make you look good? I don't understand the thinking, but anyway, I mean, judges are more and more educated about these types of things. The lawyers I expect to be snakes, you know, frankly. I expect them to do what is in their client's benefit, because these are paid lawyers. That's the deal. That's the deal. They have accepted the Faustian bargain of, this person is going to pay me money and I am going to try to win their case. I'm going to do what they want. And often what they want is not real meritorious under the legal rules, and probably not really a proper purpose under the legal rules. I think the filing of the confidential information from the child custody evaluation is a classic example of that. So the lawyers, I just expect to be opportunistic. If the domestic violence theories and principles and so forth, if that benefits the client in the case, they'll use it. And if it doesn't, they'll ignore it. They'll use the tropes instead. That's kind of their job. This is one of the reasons why my personal opinion is that I think private lawyering, the more I go on, the more I feel like it would be better if private lawyering wasn't a thing. If lawyers were like a utility, you know, pay taxes, support the lawyers. You need a lawyer in a case. Lawyer gets randomly selected and appointed to you. Make the entire legal system a quote unquote public defense type of system. Because the incentives are just so different. When you're a public defender, you don't have the incentive to just do whatever my client wants to keep them happy so that the payments keep coming in. I feel like there would be a lot more integrity in the system. It would be much more principled if that's how it operated. But it doesn't. So I don't expect principle from the lawyers. From the judges, though, it's not that they're not educated about this stuff. It really isn't. You know, they go to all kinds of trainings and you know, stuff like that. I think the problem with judges is that they get jaded. I think they see a lot. Judges are real disinclined to look at a case and see a good guy and a bad guy. It's kind of what everybody wants them to do, and they almost never do. And the reality is, like, just in normal civil practice and in the majority of family cases, that's not the situation. There is a little bit of both sides going on. But there are definitely cases where one person is the main problem. And courts are really bad at recognizing that and dealing with that. I would have expected that in family law, it would be easier to recognize, just because by virtue of the fact that we are here at a trial, we have already selected for high conflict, unreasonable, types of traits that lead you to be in this position. Most people are going to be able to make some kind of concession in order to get to a settlement. So when you have a situation where that doesn't happen, it should be a pretty big red flag. But there are problems here, and the problems may not be mutual. It may be that there is one person who simply cannot be reasoned with. And I just think courts are disinclined. They're just disinclined to think that. And I'm not entirely sure why. I'm really not entirely sure why. I feel like maybe there's something about the role that makes them want to be like Solomon-like, or even-handedly, and like, you should obviously be fair to everybody and stuff, but that doesn't mean you shouldn't see the situation for what it is. So I don't know. I don't know what the deal is with the judges, but I think in this particular case, it's just compounded by he doesn't have the context. This takes me back to my concern very early on. I don't really like that we didn't have openings. It's a very small thing. It's a very small thing, an opening statement. But it was the opportunity to introduce him and to tell him what the case is about and to summarize for him. This is a woman who is seeking vengeance at whatever cost. In her own words, she has said she has nothing to lose. She wants to drain him economically. She wants to ruin his career. She wants to damage his public image, and she wants to destroy his relationship with his children. And she has used her social media. She's used her relationships with conventional media, and she has used this litigation to carry out those goals. That's what this case is about. The judge needed that kind of introduction, and he just didn't get it. And one of the things that kind of irritates me about what he's done here and the kind of things that he said is that, on the one hand, he's made such a point of custody is not an issue, and he's excluded evidence on the grounds that that's going to custody, and we're not litigating that. So he's kind of denying himself the context that he needs to understand the big picture. But then when he makes his ruling, he's awfully happy to assume that he knows an awful lot about the big picture. And I think that some more humility about that would have been appropriate. I think presuming to lecture the parties about things that he hasn't heard about, or that he's heard only a small amount about, is unwise. It does not make him come across as, a wise, benevolent judge with so much, helpful information to hand down. It makes him sound like he's uninformed. I don't know if there's a real solution for lack of humility in the courts either. Lisa Schreiber, lesson from my hellish divorce. You can't litigate someone into being a decent human, but you can be one yourself. Thank you for your coverage on this, Andrea. Yeah, it's a great insight. You really can't. Absolutely. And people are going to do what they want to do anyway. People are going to be what they're going to be. They're going to make the choices that they're going to make. It's the need to control other people that is, it's at a pathological level with somebody like Alice and with other abusers. Like, it's so bad that it causes all of this harm, but it's also, I can't imagine a very pleasant way for them to live. I can't imagine they're happy people. You're so disturbed by things that are outside of your control. You're so attached to these things that are outside of your control. And so this constant drive to assert control, it's got to be very stressful. It's got to be a very unhappy way to live. And this is just, kind of going back to the karma thing. It would be so much more peaceful to just let that go. You'd be so much happier to just let that go, move on, accept that this is who you are and what you did, but it doesn't have to be your future. You can be better. You can be happier. You don't have to let this thing define you. Some people just don't have that in them, though, and you can't control that. It's up to them. I can dare her to prove me wrong, but it's going to be up to her. So I think this is a really good insight that if that's your goal, if your goal in litigation is to like get somebody else to feel remorse or to apologize or something like that, you shouldn't be litigating. You really shouldn't, because it's out of your control. The only reason you should litigate in civil court is because money will fix your problems and you have a good chance of getting it. So that's pretty much all litigation will do. There's exceptions for like injunctions and stuff like that, but no, for the most part, it's really good if you've lost money and you have a good case for getting some back and the opportunity to collect on it. If that's not your situation, you got to give some real hard thought to whether the court is the solution for the problem that you have. Michigan Farm Boy, if the judge didn't read the full background, that seems like an issue when he makes a decision based on presentations from lawyers thinking he had the background. It's the risk, I think, of assuming what the judge knew or didn't know. I wouldn't have assumed it if I were arguing the case. You can't assume. You can't assume what the judge knows. You can't assume what the judge thinks. It's far too risky. So I mean, if it's based on an assumption that the judge had read through the whole file and knew the whole background and stuff like that, that was a misjudgment. That was a strategic mistake. I kind of assume that for purposes of commentary. I just assume that's what a judge would do, but I can also see a situation where he'd be like, no, I got these issues to decide and I want to be as blank a slate as possible. I mean, I can see that. So it's really your job as the litigator to be absolutely sure the judge knows what he needs to know to be able to rule in your decision. You can't take anything for granted. And that can be very difficult when you've been on a case, for years and years and years. It's very easy to lose sight of what is known, what isn't known, what seems like common sense, what do you take for granted, what do you not take for granted. It's part of the preparation. And this is one of the reasons why, litigation gets so expensive. Because you got to put a lot of time into just strategizing that and thinking it through and coming up with your plans and reviewing everything and outlining everything and all that stuff. And so that can be especially difficult if you have situations like you have here where, these parties have already spent everything that they have on trying to reunify and, God knows what else in Alice's case, frozen fish and things like that. And so, if the lawyer's concerned about getting paid, he's in this kind of tricky situation of you still need to do the work, ethically. It's your responsibility to do it, but It's hard to justify prioritizing it when you got other clients that are paying the bills that keep your lights on and your staff paid and things like that. So difficult balance, and just one more reason in favor of my position to make all lawyers the equivalent of public defenders. Take those incentives out of the equation. Lucy Fair, my dad left when I was 5 and he had no interest in a relationship with us. It's tragic these children are being deprived of a dad that actually cares. It's absolutely heartbreaking and so unnecessary and so detrimental. And I shudder at the lies that these children have absorbed. You know, Alice hasn't hidden a lot of what she's done in terms of her communications with the kids, the things that she's told them about him, the way that she has handled, you know, sharing the divorce, sharing his new relationship and things like that. And she has really like gone out of her way to try to convince the children that their dad doesn't love them. I mean, can you imagine? Can you imagine needing to win so badly that you would hurt your own children like that? Medea's the archetype. It's not like we don't know these people don't exist, but it is. It's absolutely devastating, and the children have been the biggest losers in all of this. The children are the ones who have been let down by this process far more than anybody else. Children are resilient. So there's hope. I think there's still some hope that things can get better for the children, and that even if the relationship, you know, doesn't heal, doesn't mend, that they can still kind of recover from what they've had to go through, and you know, move on and develop good skills and good trust for the opposite sex in their adult lives and things like that. But it makes it harder. It's really no question. It makes it harder, and so unnecessarily. And that's what I don't like about the judge not seeing the full situation here, and not really being able to appreciate why these children are suffering the way that they are, and how little this has to do with what Ioan wants. Well, guys, I do appreciate your comments, appreciate your thoughts, your support as always. Your nice comments. I mean, I'm human. I love hearing I look good, right? It's not going to last forever already on the spiral down. But that's okay. I accept that as just that's the cost of being alive, is that it doesn't last forever. You can't be in your prime forever. And the nice thing about getting older is I am appreciating that there are values in you know, different stages of life, different benefits that you get as things get older, and you just, you know, different things start to matter more and less, and you get different insights into things with time. So nevertheless, do appreciate a little flattery from time to time. So thank you guys for that. Yeah, we are we're still not done. I mean, that's the kind of the important thing. We're still not done. We're going through another round with Ioan and Bianca. I'm guessing Ioan and Bianca tomorrow, and then Alice on Friday, just, you know, given the configuration of the parties. So still more to come out. Still more opportunities for kind of more of this backstory to be brought to the judge. Is it going to change everything? No, no, but it might help. It might staunch again some of the bleed that has been the ongoing abuse that this man has suffered, and just the indignity of having to endure the contact and having to pay her to be able to continue to do it and so forth. So still an opportunity potentially for at least a vindication of some kind of consequences to be imposed on Alice for the choices that she's made and the economic effects that that's had, not just on Ioan and Bianca and their savings and all of that, but on the children. The choice that has been made to exhaust the family resources to fight instead of devoting those resources to the kids. Still potential that there could be some consequences for that. So we'll see. I've said what my strategy would be at this stage. It's time to focus on the litigation abuse and the financial abuse, the lies about those particular issues. So we'll see what Ioan's attorneys do and what Alice's attorney does in response. So with that, guys, I'll be back at court bright and early tomorrow. Full day. Have a lot to report on. I'm going to be in a new location tomorrow, so just by way of a heads up, I am still aiming for the 7 o'clock. Slight possibility that it might run a little bit differently, just because I've got a little bit of chaos to deal with in the afternoon, and you'll find me in a different setting, different background, maybe different lights, maybe not so prison like. But I am trying to preserve the anonymity of the kind folks who are hosting me during my stay here. So that's why things are so bland at the moment. But so just be aware, slight possibility that things might run a little bit late tomorrow, but hoping not, that we'll still be on schedule for the 7 o'clock stream. And we're getting close to the end, guys. We are in the penultimate day tomorrow. So we'll see what it brings. Thank you all for joining me. Thank you, mods. Thank you, everybody. Appreciate all of you. Appreciate your interest in this case. More to come. We'll be here to talk about it tomorrow. See you then.